arrive at by considering his or her respective contribution, whether it be monetary or non-monetary. The bigger the contribution, the bigger the entitlement. Where there is evidence that a non-monetary contribution entitles a spouse to half of the matrimonial property, then the court should give it effect. But to all that Article 45.3 decrees an automatic 50-50 sharing would imperil the marriage institution. It could give opportunity to a fortune seeker to contract a marriage, sit back without making any monetary or non-monetary contribution, distress the union, and wait to reap half the marital property. That surely is oppressive to the spouse who makes the bigger contribution. That cannot be the sense of equality contemplated by Article 45.3 of the Constitution. End of quote. Emphasis suppositions. It is clear that both the High Court and the Court of Appeal have had occasion to pronounce themselves on the abuse section, the relevant provisions of the Matrimonial Property Act, and Article 45.3 of the Constitution. Both courts reviewed decided cases on the subject and the said provisions and rendered themselves as quoted above. Whereas the High Court is a court of coordinated jurisdiction and decisions of coordinated courts are not binding to this court, the decisions are highly persuasive. This is because of the concept of judicial committee, which is the respect in his first book of jurisprudence. And this to say, the decisions of an ordinary superior court are binding on all courts, absolutely binding on courts of coordinate authority, nor on the court itself, will be followed in the absence of strong appeal decisions cited above. I am alive to the fact that the passage reproduced above is attributed to Judge Kiagi. It's a written opinion by one or more judges of a court which agrees with the decision made by the majority of the court but states different questions. In my opinion, I think that strong reason to the contrary does not mean a strong argumentative reason appealing to a particular judge, but something that may indicate that a statute or some authority that ought to have been followed. I have carefully followed Justice Kiagi's process of reasoning and conclusions. They have also carefully examined the views offered by the High Court in the above decision. The learned appellate judge examined Article 45.3 of the Constitution and the abuse section and concluded that the provision does not command 50-50. I entirely agree with his reasoning for two reasons. First, he addressed the same legal provisions as in the present case. That is Article 45.3 of the Constitution and Section 7 of the MPA, that is the Marital Property Act. The section under challenge in this petition. The higher the degree of legal and factual similarity, the more weight this court gives the prior case when deciding the matter at hand. The second reason is that this pronouncement came from a superior court, superior than this one. As for the High Court decision, it also addressed the same provisions and the question of 50-50 sharing of matrimonial property. Petitioner's counsel made no efforts to distinguish these two decisions from the present case or from the facts of this case. And immediately, there is the general presumption that every act of parliament is constitutional and the burden of proof lies on every person who alleges otherwise. The court should start by assuming that the act in question is constitutional. Discussing the presumption of constitutionality of a statute, the Supreme Court of India had the following to say, quote, in examining the constitutionality of a statute, it must be assumed that the legislature understands and appreciates the need of the people, and the law it enacts are directed to problems which are made manifest by experience, and the elected representatives assembled in a legislature enact laws which they consider to be reasonable for the purpose for which they are enacted. Presumption is therefore in favor of the constitutionality of an enactment, end of quote. Perhaps the above is what Judge Kiagi J.A. had in mind when he quipped, and I quote, and it is no accident that when Parliament enacted the Matrimonial Property Act 2013, it knew better than to simply declare that the property shall be shared on a 50-50 basis. Rather, it set out in elaborate manner the principle that division of matrimonial property between spouses shall be based on their respective contribution to acquisition. On the question of the alleged discrimination, the imbued section talks of parties to a marriage. My understanding is that it means both men and women. It does not specifically refer to women. Therefore, so there are and there will be situations where women earn or will earn more than men or contribute more than men in acquiring matrimonial property. The Act expressly recognizes non-monetary contribution by either spouse. What non-monetary contribution amounts to must be determined in the circumstances of each case. The Matrimonial Property Act defines monetary and non-monetary contribution in very clear terms. To me, the guiding principles in cases alleging discrimination are clear. The first step is to establish whether the law differentiates between different persons. As stated above, the section talks of parties to a marriage, which phrase includes men, does not refer to women. The provision applies to both men and women in marriage. The second step entails establishing whether that differentiation amounts to discrimination. The provision clearly recognizes non-monetary contribution by either spouse. Non-monetary contribution is not limited to women alone. It applies to both men and women. The third step involves determining whether the discrimination is unfair. As stated above, the section has not been shown to be discriminatory in the first place because it applies to both men and women in marriage, nor has the unfairness be proved. In Willis v. United Kingdom, the European Court of Human Rights observed that discrimination means treating differently without any objective and reasonable justification persons in similar situations. It is stated, and I quote, "And distinction whether intentional or not, but based on grounds relating to personal characteristics of the individual or group, which has the effect of imposing burdens, obligations, or disadvantages on such individual or group not imposed upon others, or which withholds or limits access to opportunities, benefits, and advantages available members of society," end of quote. From the above definition, they say to state that the Constitution prohibits unfair discrimination. In my view, unfair discrimination is differential treatment, that is demeaning. This happens when a law or conduct for no good reason treats some people as inferior or less deserving of respect than others. It also occurs when a law or conduct perpetuates or does nothing to remedy existing disadvantages and marginalization. Article 45.3 of the Constitution treats parties to marriage as equal partners. That equality is reflected in the provision of the Act, which recognizes that the contribution of parties to a marriage, whether monetary or non-monetary, will be treated equally. The same equality is maintained by Section 7 of the Act, which provides that upon dissolution of a marriage, parties are entitled to share the property equal to their contribution, whether monetary or non-monetary. The petitioner's fear, as understood it, is that it is difficult to prove non-monetary contribution. I do not think so. Section 2 of the Act defines contribution in very clear terms. All that a party is required to do is to provide evidence on details of his or her non-monetary contribution in the marriage and leave it to the court, hearing the dispute to determine. I have no doubt that the court will rise to the occasion and, in the circumstances of the individual case, apply the evidence, the law, and appropriate legal skills and arrive at a fair determination of the valuation of the non-monetary contribution in the circumstances of the case under consideration and determine the respective rights of the parties in the case. That our courts are capable of doing. The interpretation preferred by the petitioner, in my view, is an open invitation to this court to open the door for a party to get into a marriage and walk out of it in the event of divorce with more than they deserve. The law recognizes equal worth and equal importance of the parties in marriage. Thus, the beneficial share of each spouse as the law on the division of matrimonial property stands in Kenya ultimately depends on the parties' proven respective proportions of financial contribution, either direct or indirect, towards the acquisition of the property. The greatest injustice, which in my view forms the basis of the petitioner's fear, as I understood it, is that there has been failure to reward or recognize a spouse whose contribution to the family has been or was through the our homemaker, performing household chores, bearing children and raising children, or a spouse who used his or her resources for the day-to-day subsistence requirements of the family and thereby deprived himself or herself of the opportunity of acquiring durable property. Historically, majority of these were or are women. Hence, the petitioners fear that women are disadvantaged. I am clear in my mind that the drafters of the Act were conscious about this, hence the clear definition of non-monetary contribution in the Act. The essence of this provision is that courts will evaluate the interest of the parties and the property and make a just and equitable distribution of the property or properties. The argument that the bill was passed amid protest in Parliament cannot suffice. It was subject to a vote as required and sailed through after the majority voted in its favor. It became law. Its constitutionality cannot be assailed on the grounds that some members of Parliament voted against it. The bill went through the legislative process and was enacted into law. I also find that the bill section does not contradict Section 6 of the Act, which provides for liabilities incurred during marriage to be shared equally. The provision was meant to curb situations where one party to a marriage would be left to settle debts incurred during the substance of the marriage. Further, the assertion that the section infringes on the right to property cannot succeed. First, the Act recognizes monetary and non-monetary contribution, which is clearly defined by providing that a party walks out with his or her entitlement based on his or her contribution. The section entrenches the principle of equality in marriage. It is my conclusion that the bill section does not offend any of the provisions of the Constitution as alleged, nor does the section contradict any of the provisions of the Act. Having so concluded, I find it odd that the petitioner does not qualify for any of the relief sought in this petition. In the circumstances, I dismiss this petition with no orders as to cost. Thank you. Call the next matter.
We will be requesting for copies.
Okay, they will be supplied. Thank you.
Yes, Ministry of Agriculture, Livestock and Fisheries.
Who is in this one? Council, your position,
My Lord, we are in agreement and we can matter.
thank you.
JR 557 of 2016.
I second it. Holding brief for my dear Lord for the respondent.
Four, let us say it. There is a restaurant, there is a interested party, two interested parties actually.
Well, not for the plaintiff petitioner.
Now we have the interested parties.
My instructions are
Yes, they can confirm service first. Will that, what does that have to do with us here? I know the matter here under another judge. With the ruling in the